Welcome to Audit the Audit, where we sort out the who and what and the right and wrong of police interactions. This episode covers arrestable offenses, resisting arrest, and anti-SLAPP laws, and is brought to us by Chem Before the Storms channel. Be sure to check out the description below and give them the credit that they deserve. On December 8th, 2022, Security Officer Stephen Bartle of the Thousand Trails Verde Valley Campground in Cottonwood, Arizona, called the Yavapai County Sheriff's Office to request a police escort for park manager Scott Woolley to speak with member Corey Drew about an ongoing dispute regarding Mr. Drew's service dog and several other issues. Deputy Samuel Contreras arrived at the scene first and found Mr. Drew parked in a white truck on the side of the road. Deputy Contreras activated his emergency lights and pulled nose-to-nose with the truck. 5 other officers responded to the call, and the interaction that followed was captured by both officer body camera and Mr. Drew's cell phone.
911, what's your emergency?
This is Verde Valley, Thousand Trails. We need the sheriff.
Okay, this is the sheriff.
Hello, this is a security officer here. We're having an issue with a guest who's become aggravated and is now threatening if we approach him.
Okay, and what is he doing?
He's threatening. He's sending texts to us because we're not answering all his questions properly, and now he says if we approach him, his PTSD is getting aggravated and it could escalate if we approach him. He wants to have the sheriff escort him down to site A42 when they arrive.
Okay, and then he wants us to go over there and escort to the mail.
He would like to be escorted down to talk to this guy, yeah.
Does he have any weapons on him that you know of?
We don't know that.
Okay.
Are they on the way, by the way?
Yeah, I do have help started that way. Is he white, black, Asian, or Hispanic?
I do not know.
You don't know what he looks like?
I haven't seen him, so I don't know.
Okay.
So are they dispatched already?
Yeah, I do have help started that way, sir. Okay. I did let them know that he is at the office right now with your manager, okay?
Do you have backup coming?
We have units responding.
Okay, thank you.
Yep. Mm-hmm.
Bye-bye.
Don't step out of the vehicle, please. What? I'm on private property, boss. Have I broken the law? Step out of the vehicle, please. Have I broken the law? No, but this officer safety, we don't know what's in the vehicle. We're going to like you to step out and we can talk to you. Well, this isn't a traffic stop.
Step out of the car. We're giving you a lawful order.
Step out of the car. This is not a traffic stop. Step out of the car. I have not broken a law. Well, I'll tell you what, you're under arrest, so get out of the car.
Get out of the car.
What am I under arrest Disorderly conduct. Get out of the car. What disorderly conduct? Get out of the car. We'll talk about it. But right now, you're resisting arrest.
Get out of the car. We're going to drag you out. We're going to break your window, drag you out. Don't do this.
What conduct did I do that was
disorderly conduct. It's a criminal charge.
Disorderly conduct?
ARS 13-2904. Anything that disrupts the peace of another. Get out of the car. You're under arrest.
Wait, you witnessed disorderly conduct to arrest?
Get out of the car.
Is there a sergeant here?
My lieutenant's right here.
Okay,
get out of the car.
Disorderly conduct to arrest me, Lieutenant?
We're trying to talk to you.
Well, he's saying I'm under arrest.
So once we're on the window, we'll talk to each other.
Well, am I under arrest or not?
We're doing an
So
investigation.
I'm not under arrest and they
okay,
just
but you're being
arrest?
detained. You're being lawfully detained.
Okay, I'll agree with you there.
So you want to act like a normal person?
Am I under arrest like this officer?
Okay, what did I just tell you?
You said I'm not.
What did I tell you? That you're being detained, right?
Deputy Contreras originally tells Mr. Drew that he's under arrest for disorderly conduct. But after Mr. Drew asks the officers if they witnessed him commit any disorderly conduct, Lieutenant Frank Barbaro says that he is not being arrested and is only being detained. Under Section 13-2904 of the Arizona Revised Statutes, quote, a person commits disorderly conduct if, with intent to disturb the peace or quiet of a neighborhood, family, or person, or with knowledge of doing so, such person engages in fighting, violent, or seriously disruptive behavior, or makes unreasonable noise, or uses abusive or offensive language or gestures to any person present in a manner likely to provoke immediate physical retaliation by such person, or makes any protracted commotion, utterance, or display with the intent to prevent the transaction of the business of a lawful meeting, gathering, or procession, or refuses to obey a lawful order to disperse issued to maintain public safety in dangerous proximity to a fire, a hazard, or any other emergency, or recklessly handles, displays, or discharges a deadly weapon or dangerous instrument. Now, violations of paragraphs 1 through 5 are misdemeanor offenses, whereas violations of paragraph 6 are felonies. And while the description that Mr. Bartle provided regarding Mr. Drew's behavior could conceivably fall under paragraphs 1 through 5, there was no evidence suggesting the involvement of a deadly weapon or dangerous instrument. Therefore, at most, the officers potentially suspected Mr. Drew of misdemeanor disorderly conduct. Section 13-3883 of the Arizona Revised Statutes authorizes peace officers to conduct warrant felony arrests based on probable cause alone. However, the statute limits the authority to conduct warrantless misdemeanor arrests to situations where the offense has been committed in the officer's presence, and the officer has probable cause to believe the individual to be arrested has committed the offense. Here, as Mr. Drew pointed out, the officers did not personally witness him engage in any disorderly conduct, and so they could not lawfully arrest him for misdemeanor disorderly conduct under the state statute. Additionally, even if the officers had personally witnessed Mr. Drew's interaction with the Thousand Trail staff, it is highly questionable that a court would conclude they had probable cause to arrest him based on his conduct during his argument with the staff, as the available video footage did not seem to rise to the level of criminal misconduct.
Sir, please step out of the vehicle.
No. Okay. So I said I'll talk to you.
Okay, do you have any weapons in your car?
I'm not going to answer any
Okay,
questions.
because this is a big difference between us taking you out or not. So you can run down the window the whole way and let us see your hands, or we're going to rip you out of the car. Roll down the window. Okay, this isn't a we're getting to the point where this isn't a negotiation, okay?
I understand my rights. I have no officer.
Okay, well, if you understand your rights, there's a Supreme Court case that says you have to get out of the car. This is a lawful traffic.
On private property?
We are stopping you. Okay,
So
do you want to argue about this, or do you want to talk about why we're here?
I want to know.
Let me see
You
both
said I'm
your
under
hands.
arrest, and you said maybe. Now I'm not stopped for a traffic stop, clearly.
You're being legally detained.
Okay, to
now we're going to knock
investigate
this out.
something. To investigate something?
Yes.
Okay. What are you investigating?
Disorderly conduct.
Okay. Where? Well, it wasn't disorderly. So, what do you want to know?
What happened?
Mr. Drew repeatedly refuses to exit his vehicle, and as a result, he was eventually charged with resisting arrest, failure to comply with a peace officer, and failure to stop or provide identification. Section 13-2508 of the Arizona Revised Statute states that, quote, a person commits resisting arrest by intentionally preventing or attempting to prevent a person reasonably known to him to be a peace officer, acting under color of such peace officer's official authority, from effecting an arrest by using or threatening to use physical force against the peace officer or another, using any other means creating a substantial risk of causing physical injury to the peace officer or another, or engaging in passive resistance. Now, while Mr. Drew clearly did not use or threaten physical force against the officers or create a substantial risk of physical injury, a court could determine that his refusal to exit the vehicle constituted quote-unquote passive resistance for the purposes of this statute, which defines the term as, quote, a non-violent physical act or failure to act that is intended to impede, hinder, or delay the effecting of an arrest. However, in order for an individual to be guilty of resisting arrest, there must be an actual attempted arrest. In this situation, although the officers did initially tell Mr. Drew that he was under arrest, they quickly changed their minds and told him that he was only being detained. Accordingly, Mr. Drew would have a strong argument that he did not resist arrest, as the officers immediately abandoned any attempt to effectuate an arrest. Now, as for the failure to comply with a police officer charge, Section 28-622 of the Arizona Revised Statutes state that, quote, a person shall not willfully fail or refuse to comply with any lawful order or direction of a police officer invested by law with authority to direct, control, or regulate traffic. However, Section 28-621 of the Revised Statutes, which is in the same chapter of the Revised Statutes as Section 28-622, clarifies that, quote, the provisions of this chapter relating to the operation of vehicles refer exclusively to the operation of vehicles on highways, except if a different place is specifically provided by statute. While, now quoting again, Article 4 of this chapter and Section 28-693 apply on highways and elsewhere throughout this state. Now, since Section 28-622 is in Article 2 of the chapter, and the statute does not specifically provide for application in a different place, a court would likely find that Mr. Drew could not be convicted of failure to comply with a police officer for refusing an order on private property. Finally, the failure to stop or provide identification charge refers to a violation of Section 28-1595 of the Arizona Revised Statutes, which makes it a misdemeanor offense for a driver who fails or refuses to stop their vehicle for lights, sirens, or other instruction by a peace officer, or to fail or refuse to exhibit their driver's license after they have been stopped. There is no evidence of Mr. Drew failing to stop for the officers, as he was apparently already parked when Deputy Contreras activated his lights, or refusing to provide his driver's license in the available footage.
What? I mean, I have on film me just talking to him very, he was not, we weren't meeting, but we were together.
So I tried to arrange a meeting with us. We had an incident. He got in one of my security guys' face last night, so I tried to arrange a meeting with the guy. Then he got all pissy on a text with security, even though I'd sent him an email to meet with me about his actions. So then he came up and just stormed the office. Very combative. We have a history at one of the other parks of being combative. He recorded me the whole time. I just wanted to have a professional conversation.
Describe combative. What does that mean?
Raising his voice extremely high.
Okay, so yelling?
Not listening to my side. He's recording me.
So how close was he when he was yelling at you?
Oh, within 3 feet. But he was yelling and using it as what the conversation was last night. So it wasn't like... He's very intimidating. I mean, that's all I can say.
Was he cussing?
No cussing.
Okay, did he threaten you?
Just said he was going to take it to legal and corporate.
Okay. So, what are you guys wanting done?
Well, he can't really stay here.
Do you want him trespass from the property?
Yeah, he can't.
Okay. And you guys don't want him here anymore because of him violating whatever policies, rules you have?
Well, at this point, since it's got combative like this, and that it's going to escalate, and even though he didn't even respond to my email about meeting with me, and then he just came to the office.
You want him trespassed now, and you want him off property now? Mm-hmm. Okay.
Is this your call?
No, it's
who's calling you? It's yours? All right, so here's the deal. Do we have disorderly conduct?
With him, it doesn't sound like it was necessarily disorderly. Mm-hmm. He was argumentative, went into the store or whatever, and last night had gotten into an argument and gotten into a security guard's face. That was last night. Today he went in there basically doing this, argumentative, yelling, screaming.
He was yelling and screaming.
No profanities, no threats. He was about 3 feet away from the guy the whole time. No,
like if you look at the disorderly conduct statute, I mean, does this guy fit the statute? Basically.
So I think.
And then I don't think they could trespass this guy because
it's private property.
You buy into this.
They might be violating their own policies or their own whatever the heck, and they might have a lawsuit on the civil side, but it's still private property. They can kick him out if he wants.
Yeah, but he's part of an owner, though.
Okay, so he's not just camping here?
I don't know. Let me ask this dude what's...
Well, let me go ask him real quick.
Because he said he paid $6,000.
Oh, I didn't hear that.
Like, if he's a member in this...
Is that any different than like a timeshare guy that buys into something and staying at a hotel? Like, it's no different.
So as far as the hotel goes...
Well, okay, so let me ask you this. Are you guys willing to f*** this guy up? Because that's what's going to happen.
No, I mean, we're going to... I'm not here to...
No, absolutely not.
I'm not here to fight or anything like
absolutely
that.
Not.
So that's what I mean. So we got this murky civil process. So why are we going to put ourselves in a line? Because it really doesn't change our life if we walk this guy or not. Okay. And if we don't know for sure that he's trespassing, I mean, like, let's look at the trespassing statute and see. But if he's not absolutely trespassing, if he has some type of property rights to this,
I'm going to go ask them what exactly his role as far as does he live here temporarily? Kind of like, does he rent basically?
He has 20. Here, I got some paperwork in here for sure.
And then he has what I'm thinking too is that you know, you can't just, when you look at some of these are like residential things, like that guy and these guys with the porches. So, you know, that's what it makes it look to me like more of a landlord-tenant thing, or maybe they might have to, their corporate might have to sue this guy to kick him out of the park.
That's interesting.
You know, because he's probably violating the terms of his contract. You know, there's probably some language in there that says, hey, I can't be an asshole when I'm staying here, but that's not us to enforce. You know, so, you know, that's what I mean. It's like we could seriously put the hurt into this guy.
Yeah. Well, and that's not the route I want to take.
No.
I mean, but that's where it's going to go.
I'm not that this is anything, but the reservation number, and they got a 21 night reserve in and out, so it's not like he's got his member number though. So I don't know what this means in comparison.
Yeah, we got to kind of figure out what his deal is as far as property rights.
The reason I'm staying is because I have a right to stay and I haven't done anything wrong.
Okay. And we're going to figure that out, Cliff. All right, thanks.
Corey, I apologize. I made a mistake in saying that you're under arrest for disorderly conduct.
He says that he has basically like a timeshare through Thousand Trails.
It's a membership. We control it. It's a privilege. It's not a right.
Okay.
And I mean, we could basically suspend him or terminate his membership at this juncture for acting like he is. So he has no rights to be here.
Okay.
At all.
So how long does
He doesn't lease a site. There's no tenant-landlord agreement or nothing.
So he doesn't fill out any rental agreements or anything like that?
No rental agreements at all. It's a right to use contract. I even put all of our rules in here related to the issue last night, and all of our membership rules.
Mm-hmm.
And one of them is being disruptive. We're not abusive or disruptive behavior. That's one of them. You know, I know if he has a service animal, we have to be respectful of that, but the dog wasn't under his control. It wasn't leashed. He had an electric vehicle in the lodge, which we don't allow vehicles in the lodge.
So that's your guys'...
Those are all our rules that I sent him.
As far as... So he hasn't filled out any lease agreements?
No.
Or rental agreements?
They're just right-to-use contracts to use our facilities. That's all they are, and so at this juncture, we could submit him up for suspension or termination, depending on how he goes with this.
Okay. All right. Well,
so it could affect his future usage of our membership, but there is no tenant landlord.
Hello, security.
Just hang tight for me, okay? I'm terrible with names. Corey, right? Yeah. Okay. All right, you're free to go. And I'm going to ask you. You don't have to.
Yeah.
Would you be willing to show me the recording?
Yes. Okay. I will show you the recording. Of in here?
Of the incident.
Now that we're done, you release me and we're good to go. I'll shut off my phone and
you're 100% free.
I'll just show you so that you can get the tone of what was going on there. Here's security when he says I was out disorderly at security. So I'm walking around. I think it stalls for a second because he
You guys just want to watch that. I'm gonna go talk to them. Okay, so after talking with my lieutenant, so we think this is more of a civil dispute between the two, okay, between the company and him. So I'd recommend going to court to get him taken away from the property, evicted, never to use the company again.
Well, we don't need to go through court. We can suspend him today.
That's
but how do we get him off the property?
Again, we're being told that he has some sort of agreement that he's allowed to, okay? No. But we don't know, okay? So we're going to leave it at that. We're going to tell him that he's not to have any contact with you, and any of you, okay? And vice versa, you guys just leave him alone. Now, if something disorderly happens to the point where he's threatening, okay, meaning I'm going to hurt you, I'm going to kill you, I'm going to break whatever, I'm going to burn stuff down, whatever, or he's trying to fight you guys, okay, squaring up, bowing up, getting in fighting stances, cussing at you, yelling at you, call us, because then we can come back, okay, because that's disorderly conduct.
But by our rules, and he's subject to our rules, if we can ask him to leave at any time.
You can ask him.
Yeah, but he's not going to.
But we can't force him right now. And talking with my lieutenant, he's agreeing that we're not going to force him to leave. Okay, because it sounds like a big civil issue between you guys. Does that make sense?
I guess that's, I mean, in other incidents we've had before with similar issues, we haven't had that problem with asking someone to leave. I think he's just really pushed the line.
Mm-hmm.
I mean, I know we're hearing some of what he's saying. I mean, I know he's putting you guys in a bad light too.
Mm-hmm. It's just that we have to listen to both sides. We have to come up with a solution. Okay, and we've determined that there's no crime.
No, there's no crime.
Okay, so that's where
just breaking member rules.
and that's not a law crime. So does that make sense? So
Yeah, it's still competitive.
I know. So, but okay. Well, just if something else happens, call us. Okay. All right.
Okay, thanks.
All right.
Tim, oh man, you guys, trust me, this is gonna get real.
That looks like that's that. Like that one.
So then,
Why did that stop recording though? Was your interaction done with
I
them?
walked away. I was like, this is gonna get, and I just walked away.
Convenient.
Convenient. What's convenient?
Oh, nothing.
You have the other ones on there?
What's convenient?
The fact that you stopped recording when you wanted to.
When I walked away, it was convenient.
Yeah.
Dude, what is your problem, bro? Are you looking to? You see this? Are you
We're
recording?
all recording. I'm recording. I'm not
Okay,
hiding anything.
good. I'm gonna get that body cam, bro.
Okay.
I'm gonna file a complaint on you.
Okay.
That's out of
Do
line.
you have any other videos?
Convenient? You know exactly what you meant by
You're
that.
choosing to record what you want. How
I'm
do I-
recording the whole interaction. I turned and walked away. And you're
So-
telling me that's convenient? Were you there? Do you know what happened? I'm trying to give you
Do you
evidence
want me
right
to
now, and you're
explain
starting
myself
to you.
I'll leave LT. I'm sorry. That was my
All right,
mistake.
man.
I apologize, sir. I'm leaving.
Yeah, you shouldn't have said that.
Yeah, no, I'm sorry.
Because I was going to try to talk to him afterwards and ask him not to put on YouTube.
Well, that was going to happen anyways, so.
Mr. Drew was allowed to leave with no further incident. The next day, he filed a complaint with Lieutenant Joe Johnson of the Yavapai County Sheriff's Office and uploaded his cell phone video footage of the incident to his YouTube channel. According to a lawsuit filed by Mr. Drew, Lieutenant Johnson replied to the complaint on December 20th, 2022, informing Mr. Drew that he would be, quote, addressing things which should have been done differently. When Mr. Drew pushed for further details, Lieutenant Johnson informed Mr. Drew that he would review so-called civil rights issues and communication de-escalation skills with the first two deputies, and that the agency was developing additional training on these issues for patrol deputies. Mr. Drew's YouTube video then began to go viral, and the department began to receive phone calls with complaints about the incident from citizens. On December 27th, 2022, Mr. Drew indicated that he would like to escalate his complaint, and in response, Lieutenant Johnson reversed his decision on the complaint. On December 29th, he ordered Deputy Larry Hooten to reinvestigate the incident at Thousand Trails. And on February 16, 2023, Mr. Drew was arrested on 2 counts of disorderly conduct, 2 counts of threatening or intimidating, resisting arrest, failure to comply with a police officer, and failure to stop or provide identification. Mr. Drew represented himself in court. And on February 15, 2024, the resisting arrest, failure to comply with a police officer, and failure to stop or provide identification charges were dismissed for a lack of probable cause. For the remaining 4 charges, Mr. Drew filed a motion to dismiss under Arizona's so-called anti-SLAPP law, which is short for Strategic Lawsuit Against Public Participation, and the charges were dismissed on March 1st, 2024. Anti-SLAPP legislation is generally aimed at protecting individuals from civil litigation intended to chill free speech on matters of public concern. However, Arizona's anti-SLAPP statute is unique in that it was amended in 2022 to not only apply to civil lawsuits, but also criminal prosecutions. In fact, as of the date of writing this episode, Arizona is the only state in the U.S. that has allowed an anti-SLAPP type defense to apply to criminal prosecutions. The law is outlined in Section 12-751 of the Arizona Revised Statutes and is titled Strategic actions against public participation rather than strategic lawsuits against public participation. So technically, Arizona has an anti-SLAPP statute rather than an anti-SLAPP law. The anti-SLAPP law is applicable to, quote, any legal action, which the statute defines as including both civil lawsuits as well as any criminal prosecution, excepting drug trafficking offenses, riots, certain quote-unquote serious offenses, or violent or aggravated felonies. Essentially, the statute states that when a covered criminal prosecution, now quoting, involves a person's lawful exercise of the right of petition, the right of speech, the freedom of the press, the right to freely associate, or the right to peaceably assemble, the defendant may file a motion to dismiss the charges. The defendant must then establish, now quoting, prima facie proof that the legal action was substantially motivated by a desire to deter, retaliate against, or prevent the lawful exercise of a constitutional right. In other words, the defendant must put forth sufficient or adequate evidence that supports the claim that they are being prosecuted in retaliation for exercising their First Amendment rights, or in order to discourage them from exercising those rights further. Once the defendant provides this so-called prima facie evidence, the burden of proof then shifts to the prosecution, who must show, now quoting, that the legal action on which the motion is based is justified by clearly established law, and that the responding party did not act in order to deter, prevent, or retaliate against the moving party's exercise of constitutional rights. The statute explains that the prosecution can do this by establishing that the person who initiated and conducted an investigation that resulted in the legal action and that made the decision to pursue the legal action was unaware of the defendant's lawful exercise of First Amendment rights, establishing that the state actor has a consistent practice of pursuing similar legal actions against similarly situated persons who did not lawfully exercise First Amendment rights, or producing any other evidence that the court finds sufficient. If the prosecution does not meet their burden of proof, then the anti-SLAPP statute requires that the motion to dismiss be granted. Now, in this case, the court found that Mr. Drew had provided prima facie evidence that the prosecution was motivated by the filing of his complaint and or the sharing of the altercation on his YouTube channel, and the state failed to rebut this evidence and prove that the prosecution was not, in fact, motivated by his First Amendment protected activity. Accordingly, the judge dismissed the remaining criminal charges. On March 18, 2024, Mr. Drew filed a pro se federal lawsuit against Thousand Trails and the individual staff members involved in his arrest and prosecution. And on April 19, 2024, he filed another pro se suit against the Yavapai County Sheriff's Office and the individual officers involved. As of the date of writing this episode, both lawsuits are still pending. Overall, the Yavapai County Sheriff's Office gets an F for unlawfully threatening Mr. Drew with arrest for disorderly conduct, apparently retaliating against Mr. Drew for filing a complaint and publicly sharing the encounter on his YouTube channel, and pursuing criminal charges against Mr. Drew without probable cause after Lieutenant Johnson had initially determined that the officers committed civil rights violations. Now, while their behavior was far from perfect, I do appreciate that Lieutenant Barbaro was able to de-escalate the situation after the initial threats of unlawful arrest, and that the deputies on the scene allowed Mr. Drew to leave without arresting him or involving themselves in what appeared to be a civil matter. However, any goodwill these actions may have earned the sheriff's office was completely obliterated by Lieutenant Johnson's reprehensible actions after Mr. Drew indicated that he intended to escalate his complaint and the encounter began to garner negative attention for the department. While I always give officers and citizens alike the benefit of the doubt, I cannot think of a non-retaliatory explanation for this chain of events, and I believe it is likely that the reinvestigation and prosecution of Mr. Drew was motivated by his First Amendment protected activity. Mr. Drew gets an A for confidently and respectfully asserting his rights, filing a complaint and sharing the video on YouTube immediately after the encounter, and taking appropriate legal action both in his criminal defense case and in filing civil lawsuits. Although I believe it is possible that a court could conclude that Mr. Drew was legally required to step out of the vehicle, this is far from a certainty, and I am more than impressed that Mr. Drew was able to successfully have all of the charges against him dismissed as a pro se criminal criminal defendant. It is clear that Mr. Drew has devoted significant time to studying the law and civil rights issues, and I commend him for his tenacity and commitment to police accountability. I wish him the best of luck in his pending lawsuits, and hope that his actions will make the Yavapai County Sheriff's Office think twice before taking retaliatory actions against a citizen in the future. Let us know if there is an interaction or legal topic that you would like us to discuss in the comments below. Thank you for watching, and don't forget to pick up your copy of the Civilian Rights Hand Guide in the links below.